I'm starting.
Oh, I'm on camera.
Hi, good afternoon. I'm Gregory Vadas, Chief of the FCC's Office of Intergovernmental Affairs. Thank you for joining us. Welcome to another one of the Commission state and local government webinars, a webinar aimed specifically at state and local governments, covering things, Commission items that you've asked us to brief you on and that we feel are important to you and will help you in many ways. Thank the Chairman's Office for giving us the support to continue these ongoing webinars. On today's agenda, we're going to speak about Lifeline. We're going to speak about actually 3 June items: Lifeline Modernization, the NPRM that came out, the Effective Competition Order, which also came out in June, and the Commission's efforts to protect consumers against unwanted calls and text, unwanted robocalls and text. And that was also a June item. So let me just say a few words about each of these items briefly. The Commission took significant steps to modernize its Lifeline program this June. It saw a comment on restructuring the program to better support 21st century communications while building on our existing reforms to continue strengthening protections against waste, fraud, and abuse. Lifeline was established in 1985 to make phone service affordable for low-income Americans. In 2008, the Commission expanded the program to allow participation by low-cost wireless providers. In 2012, the Commission also made some more reforms. And 30 years later, we're taking another look. The June order took another look at Lifeline, and it put out a few more proposals which we saw comment on. The proposals include adopting minimum service standards for both voice and broadband service, whether broadband should be a required offering of Lifeline providers, how to encourage more competition to improve price and service, and importantly for our state and local participants, a national verifier program, which Ryan Palmer will speak about, and how states could, what action states could take to bolster Lifeline programs. We're also going to hear about an effective competition item dealing with cable franchising. In the Cable Television Consumer Protection Act of 1992, Congress instructed that where the Commission found effective competition existed among pay TV providers, such competition was preferable to using local rate regulation to protect consumers. Congress determined by statute that effective competition existed in communities where there are more than one paid TV provider in the market serving more than 15% of the community. So under the Act, under the 92 Act, pay TV providers were able to petition the Commission to determine if effective competition exists, therefore relieving them from basic service tier rate regulation. June's order, the Commission's June order reversed this rebuttable presumption. We'll hear a little bit more about that from Nancy Murphy, an Associate Chief in the Media Division. And finally, we're going to speak to you about our order dealing with robocalls, unwanted calls and texts that also came out of the Commission in June. American public has asked us repeatedly to do something about unwanted robocalls. In June of this year, we did. Over the past several years, hundreds of thousands of consumers have made their voices heard by complaining to the Commission about these unwanted calls. And in June, we decided to help them gain some of their privacy back. The June 18th order to protect consumers against unwanted robocalls and spam text. It clarified our rules, and the way it was teed up is we had several petitions for declaratory ruling in front of us, and we clarified our existing rules. So I don't want to steal our speaker's thunder. We're very lucky to have Ryan Palmer with us to talk about Lifeline reform and modernization. Ryan is the chief of the Telecom Access and Policy Division in the Wireline Bureau. That's all things universal service, so Ryan is a very important person for all of you out there in our state and local world. And importantly, Ryan's a former commissioner at the West Virginia Public Utilities Commission, so Ryan is used to dealing with issues that affect states all the time. So thank you so much for your time and expertise today, Ryan, and without further ado.
Okay, good. My microphone's on. Thanks for having me today. Thanks, Greg, and everyone else who set this up. I'm going to give you a brief history of the Lifeline program, followed by a review of the June Lifeline Modernization, FNPRM, and Order, which takes action and seeks comment on a number of important measures in the Lifeline program. Obviously, front and center in that discussion is the proposal to bring broadband into the program. Also front and center is the FederalState Partnership that drives the program, and it will be of particular interest to this group. So the FCC initiated the Lifeline program, as Greg said, in 1985 to ensure affordable phone service for low-income consumers by giving Lifeline subscribers a benefit that applies to their phone bills. It has currently and historically been on voice only. In order to be a carrier who participates in the program, you must be designated as an ETC or an eligible telecommunications carrier, which more than often than not is done at the state level, as you all most likely know. Sometimes the FCC designates states, but the vast majority are done at the state level. Subscribers are eligible to participate in the program based on income level or participation in a qualifying assistance program, such as Medicaid, SNAP, which was formerly called a food stamps program, Supplemental Security Income, or SSI, Federal Public Housing Assistance, LIHEAP, TANF, and National School Free Lunch Programs. So those are the programs through which most people become eligible for the program. Also, low-income consumers living on tribal lands may qualify by participation in one of a few specific programs as well. Currently, the monthly support that you receive for being in the Lifeline program is $9.25 per month, or if you're on tribal lands, it can be up to $34.25 per month. And while this program has not historically been a free program, in the current Lifeline program, the vast majority of consumers receive free mobile wireless service for the $9.25 Lifeline benefit, which typically gets a subscriber about 250 minutes and some amount of text messaging per month. The Lifeline benefit also applies to landline voice service and provides $9.25 per month towards the monthly landline voice bill, or a bundle that includes a voice component. In 2008, the Commission expanded the program to allow participation by low-cost wireless providers. Unfortunately, these steps were taken without instituting the kinds of controls necessary to protect against abuse, and the program almost tripled in size from 2008 through 2012, from $784 million in 2008 to $2.2 billion in 2012. So in the 2012 Lifeline Reform Order, the Commission made significant strides and reforms, and one of the most impactful reforms was the creation of a duplicate database, otherwise known as the National Lifeline Accountability Database, or the NLAD. The NLAD is used to ensure that someone applying for a Lifeline benefit does not have another duplicative Lifeline subscription with another carrier or even with the same carrier. The NLAD has been up and running since early 2014 and has successfully guarded against duplicative subscriptions and weeded out a number of duplicative subscriptions that were in the program already. This has saved the fund a significant amount of money. The 2012 reforms also required carriers and or state administrators to recertify each consumer's eligibility once per year to ensure that the subscriber is still eligible for the program and still wants to participate in the program. These reforms, and many others, successfully reduced waste, fraud, and abuse in the program, and as a result, Lifeline program disbursements declined from the $2.2 billion high water mark in 2012 to about $1.6 billion in 2014. So savings of approximately roughly $600 million in those 2 years. On June 18th of this year, the Commission issued a notice for proposed rulemaking that, at its core, seeks to rebuild and modernize the Lifeline program. Now, before I turn to a summary of the item, I want to stress what the Commission found in June, and that is that one of this Commission's most fundamental responsibilities is to ensure that all Americans have access to vital communications services and that there is a critical need for the Lifeline program to transition to support broadband now. The Commission recognizes the critical role broadband access and adoption play in improving the lives of all people and found that the ability to participate in society and the digital economy increasingly requires broadband for education, healthcare, public safety, and for persons with disabilities to communicate on par with their peers. As we ensure that Lifeline is restructured for the 21st century, the Commission wants to ensure that any Lifeline offering is sufficient for consumers to participate in this economy. Like I said earlier, the Commission also recognized the important role of state and local governments and the role that you all play in this space. Over the past few years, Lifeline has become more efficient and effective due to the combined efforts of the states and the Commission. And through working together with the states and leaning on your expertise and experience, we hope to have an even better program as we move forward. The Commissioners clearly recognize the important role you all play in this space, and input from the states and local levels will be critical if we want to move the program where it should be in the future. I should note that Lifeline will be the last universal service program to move to supporting broadband, and the majority clearly believes that the time has come to take this final step. That being said, it has to be done in a calculated, measured way that protects the fund against waste, fraud, and abuse, and this item builds upon the successful reforms from 2012 Lifeline Order by making the program more transparent and more efficient. So let's talk about the significant proposal to modernize and rebuild the program by bringing broadband into it. When the Commission looked at the current Lifeline program and the current Lifeline market, it was clear that the offerings to subscribers had remained stagnant since 2012 at around 250 minutes per month with some amount of text, despite a rapidly evolving and increasingly competitive market. The Commission wanted more for subscribers and for our USF dollars, and therefore asked what minimum service levels should be for broadband and voice, both fixed and wireless, in the program. By setting minimum service standards, the Commission would guarantee that Lifeline subscribers don't receive a second-class service. The Commission doesn't propose certain numbers or speeds, but asks what should the standard be tied to, and how can we measure it as standards and the industry evolve over time. For instance, should the level of service be what is subscribed to by a substantial majority of residential customers? If so, how should we interpret substantial majority? And how does affordability factor into the equation? The Commission also addressed the big issue of should subscribers be required to contribute towards their service. The Commission proposes to keep the Lifeline benefit at $9.25 per month. If we want subscribers to have robust services and the subsidy is to remain at $9.25, then is it inherent that they will need to pay something for broadband? How would this help address waste, fraud, and abuse? On all these important issues, the Commission seeks and quite frankly needs your input. Currently, another issue that came up in the item is regarding third-party eligibility determinations. Currently, ETCs determine whether consumers are eligible to participate in the program. Many believe that this presents an inherent conflict of interest. So in the item, the Commission proposes to remove this responsibility from the hands of the ETCs and put it in the hands of a trusted third party, and seeks comment on the best way to do so. I believe this is something that has a lot of support from the states, and I know it does from the Hill. When I was recently attending a NARUC meeting, a summer committee meeting, we heard a lot of support for removing this eligibility determination from the hands of the providers. So this is something we're looking at and we're taking very seriously. The item notes that a number of states have been proactive in their efforts to establish state eligibility databases or other means to verify Lifeline eligibility, and we commend these states and seek comment on the best way to build off these successful efforts. The Commission also seeks comment on establishing a national third-party verifier to make this eligibility determination. Similar to the system that we've seen in California and other states, a national verifier would review consumer eligibility documentation to verify eligibility and could perform other functions, for example, recertification and outreach. We seek comment on ways that a national verifier could work together with existing state verification systems and databases. For example, we seek comment on a way for states to opt out of any national system similar to the opt-out process for the NLAD, which is the National Lifeline Accountability Database. The Commission also addressed steps that can be taken to encourage additional state Lifeline funding. Specifically, in paragraph 82 of the item, the Commission seeks comment on how to incent states to develop dependable processes to verify consumer eligibility, and whether the Commission has the authority to utilize universal service funds to finance the development and implementation of Lifeline eligibility systems at the state level. The Commission also asks whether the Commission rule requiring providers to implement procedures to ensure their subscribers are eligible could be interpreted to require providers to fund a state eligibility database. Another issue in the item that would be relevant for states is coordinated enrollment. The item asks questions about coordinated enrollment and ways we can work with federal and state agencies to educate consumers about and simultaneously allow consumers to enroll in the Lifeline program. For example, when a consumer applies for SNAP benefits with a state agency, the consumer could also enroll in Lifeline. The Commission asks how Lifeline benefits could be placed onto existing benefit cards like a SNAP card and whether this process would work for the Lifeline program. State and local input is critical to determining how best to implement coordinated enrollment because most of the benefit programs that qualify consumers for Lifeline, such as SNAP and National School Lunch Program, are operated at the state level. Other matters that were in the item that you may be interested in are targeted at further combating waste, fraud, and abuse, and also making the program more competitive and open so we can have more competition and more providers participating. Some of the questions were centered around streamlining ETC requirements, adjusting the programs that qualify a person for support by either adding or eliminating programs, establishing standards for eligibility documentation because many of these documents, such as SNAP and Medicaid cards, are issued at the state level, establishing uniform certification, recertification, and household worksheet forms so there be consistency across all states, and rules for the assumption and transfer of ETC designations and ETC subscriber base. While much of the item was devoted to the further notice for proposed rulemaking, the Commission also went to order on some important issues. Perhaps the most important action in this space was requiring ETCs to retain eligibility documentation. In the 2012 Lifeline Reform Order, consumers were required, for the first time, to certify and provide proof of eligibility upon enrollment in the program. Our rules built upon efforts of a number of states that had already put in place similar requirements. Until the most recent order, ETCs were not permitted to retain these eligibility documents. And this has presented a big challenge when auditing these carriers for compliance with our rules. The order from the June 18th meeting has changed this, and now ETCs are required to retain copies of the documents they review when verifying consumer eligibility or conducting recertification. This is an important action that will help ensure that only eligible consumers enroll in the program. So there you have it from a very high level, a summary of the Commission's most recent Lifeline item. There are many, many more issues teed up in the June item, and initial comments are currently due on or before August 17th, with reply comments due on or before September 15th. However, we did receive a filing on Friday requesting the extension of those deadlines, and the Commission will be looking at that quickly. I'd like to remind you all also that Lifeline Awareness Week is coming up in September 14th through the 18th. Now, due to the Commission's focus on modernizing and moving the program forward, we have not created any new documents or information for dissemination this year, but we have reviewed the documents that are available from last year and updated those. So when the states are working on their outreach efforts, that information is available. I know that when I was at the West Virginia Commission, we would do press releases and maybe an event for the media or the local news, and we encourage states to share information about what has worked well for them so everyone can learn from the experiences of each other in the different states. Of course, if the Commission is successful at modernizing the program, Lifeline Awareness Week next year and the program in general will be much different, so we'll have much more to report. I'll be happy to answer any questions at this time.
Thanks, Ryan. That was really a great summary of the issues in the NPRM focus states and local governments. I think we were having some technical problems with emails coming to livequestions@fcc.gov. So if folks out there have any questions, please email them to me now, gregory.vatis@fcc.gov. That's gregory.vatis, V as in victory, A as in alpha, D as in David, A as in alpha, S as in September, @fcc.gov. And Ryan will stick around a minute or so to see if any questions come in.
Absolutely.
Thanks. And our technical folks will let us know when the live questions are back up. I think what? Just hang on. Thanks. I think the national verifier, I don't know if anybody has any questions on that. And the Lifeline order, if anybody wants to, the notice of proposed rulemaking rather, and it's the order on reconsideration. Anyway, it's the FCC number of the document is 15-71, and as I read it over a few times, I think the executive summary is really good, and particularly paragraphs 8 to 10 of the order really would help focus you folks out there. Has the reply comment date is it?
No, right now replies are due, or the first round of comments are due August 17th, and the replies are due September 15th.
Okay, so we'd encourage all of you out there to file. August 17th is the comment, and September
15th the replies.
Okay, great. And of course, if you want to come in and meet with us ex parte, you're welcome to do so. We always love to hear from you guys on. You're the ones on the grounds also implementing it in the states. So we need
absolutely,
to know what works and doesn't.
And like I said, a little bit in my introduction, that the FederalState Partnership and learning from your all's experience and expertise was a common thread throughout the item, throughout the FMPRM. So the Commission realizes that we can't modernize the program without coordinating and learning from the states and sort of the boots on the ground as to how these changes would impact the program.
Okay. Is the live questions email working? Okay, great. We hear live questions is up and running, so you could go ahead and email to livequestions@fcc.gov. All that's on the bottom of the event page, and I see our folks in AV put it up on the screen, so thanks. Anything Ryan doesn't get to now, we're gonna let him go. He's a very in-demand person, heading up all the universal service programs. That's probably the understatement of the year. I will work with Ryan to get you answers offline.
Absolutely.
Thank you so much, Ryan.
Thank you.
Great. Next up, we have Nancy. Let me do these cards here. Sorry, Nancy. Some things are still low tech. Next up, we have Nancy Murphy, Associate Chief in the Commission's Media Bureau, and Steve Brocart. Let me get Steve's Senior Deputy Chief in the Policy Division of the Media Bureau. They're here to speak to you about the effective competition item that I spoke about in my introductory remarks, our June order reversing the rebuttable presumption. And I know whether it's statewide franchising, countywide, citywide, municipality-wide, this really affects and impacts all of you. And I had a request from a number of the state and local organizations for a briefing on this. So 6 weeks later, here we are, and I know Steve and Nancy have put a lot of thought into this, so thank you.
I have a quick announcement to start off with. This is still an open proceeding, so we'll be happy to take questions, but they should be procedural in nature. If you have any questions or advocacy points that you'd like to make, that will require you to file an ex parte notice with the commission. So I just want to make sure you're aware. If you don't want to go the ex parte route, please keep your questions to the procedural realm. And so with that, I'll start off setting the stage for how this order came to pass. In 1992, the Congress passed the Cable Competition, Consumer Protection and Video Competition Act. And again, that was 1992. That was 23 years ago. So it was a dramatically different marketplace than what we're looking at today. In fact, in 1992, 95% of the market was held by the cable operators. DBS did not yet exist, and telco providers had just really begun to enter the market. Contrast that today with the largest MVPD provider is not a cable provider, rather it's DirecTV, or as the case would be today, it's AT&T after the merger. So AT&T is the largest. Out of the 5 largest video providers, 3 are not cable providers. They're either DBS providers or they're telco providers. So cable share has shrunk from 95% of the market to almost half and half being cable, a little bit more than half cable, a little bit less the other competitive providers, DBS and telco providers. Add to that the emergence of over-the-top providers, and you really see a dramatically different competitive marketplace. Today, 7% of consumers subscribe to broadband and over-the-top service and no traditional video provider at all. So the FCC, back in 1992, was instructed by Congress to create rules to establish rates that would approximate what rates would look like in a competitive environment absent true competition. And so effectively, we were charged with developing a formula that would approximate competitive rates. As part of the 92 legislation, the Commission was also tasked with preparing an annual price survey so that we could track the progress of rates over a period of time. And what we saw historically was that once a community received a finding of effective competition, that those rates were higher than communities in which there was either rate regulation or rate regulation had never been initiated. However, in the last 4 years, we've seen a reverse of that trend. And in fact, now communities with the finding of effective competition have significantly lower rates than those without a finding. So in other words, effective competition communities' rates, they're not regulated anymore, have lower rates than communities with the finding that continue to be rate regulated. So those rates can be anywhere from 36 cents lower to 64 cents lower. There's 1 year in that 4-year period where there's an exception and the rates happen to be 2 cents higher on average. So whereas our rates under rate regulation were designed to basically create lower rates, we're finding recently that, in fact, once communities are removed from rate regulation, their rates are lower than communities that are still regulating rates. And then during the course of a 1-year period from 2008 until 2009, the Commission issued findings of effective competition for almost 4,000 communities. And though we may not have sustained that rate over the intervening years, we've continued to issue findings, and virtually all of the effective competition petitions that are filed at the Commission meet the statutory definition. And so with that, I'll close and I'll turn it over to Steve, who will go through the actual procedural piece. And I just want to reinforce that this order only changed the presumption on one of the 4 tests. There are 4 effective competition tests. We only changed the presumption for the competing provider test. So Steve, that's off to you.
Okay. The first thing I want to point out is that the upshot of our order is not that LFAs can no longer regulate rates. What the upshot is they have to justify that they should be regulating rates by overcoming the new presumption that there is competing provider effective competition everywhere. How is this going to work practically? Within 90 days of OMB approval of our new rules, which has not occurred yet, and we will be issuing a public notice announcing that OMB has approved the rules when they do. Within 90 days of that date, LFAs that think that they can counter the new presumption need to file a new Form 328 certification form with the Commission. That form is going to look very, very much like the old form with 2 exceptions. One is it will announce the form will announce the new presumption of competing provider effective competition, and entities filing the certification will have to file a detailed supplement to the form showing that the presumption of competing provider effective competition is not applicable to their particular franchise area. What should that attachment look like? It should look very much like what cable operators have been filing over the last 20 plus years to overcome the presumption of no effective competition. So basically, we will need to see numbers based on the percentage of subscribers subscribing to the services of providers other than the largest provider in the franchise area, and that number should show us that it is lower than the 15% penetration threshold in the competing provider effective competition test. How is this going to play out if an LFA at the end of that 90 days does not file a new Form 328, then their certification will lapse, and we will produce a public notice to that effect, basically saying we received Form 328s from these local franchising authorities, and we are going to process those as we say we will in our rules, and that anyone else who did not file a timely Form 328 by that time, their right to regulate rates will lapse. That does not mean that they can't at a future time if they think the 90 days wasn't enough time for them to do that, their certification will lapse. But any time thereafter, if they think they can overcome the presumption of competing provider effective competition, they can file Form 328. They're not foreclosed from doing so in any way. And how are we going to process these certifications and pending petitions for effective competition that are opposed by LFAs? Basically, the certification will become effective within 30 days unless the Commission informs the local franchising authority that their certification was not any good. In keeping with our prior procedures, cable operators can file a petition for reconsideration of the certification of the local franchising authority, which will stay rate regulation until the Commission acts on that. And what would the petition for reconsideration filed by a cable operator look like? It would argue either that it is subject to effective competition under one of the other three statutory tests, the low penetration test, the municipal provider test, or the LEC test. In that case, the burden would be on the cable operator to show that that test is met, because we only changed the presumption with regard to the competing provider test. So it could show it's subject to one of the other three tests for effective competition, or it could file and dispute the contents of the supplement filed by the local franchising authority, basically showing that there are flaws in the LFA's supplement to their Form 328 such that the Commission should not find that the presumption of competing provider effective competition has been overcome. So, as I said, 30 days after it's filed, if the Commission does not inform them that it is their filing was flawed in some way, they will be certified to regulate rates. With regard to pending opposed effective competition petitions for reconsideration, applications for review, what we will do is wait and see. Well, we will be, as the order allows, we will be processing as many of those as we can before the 90-day period runs, so that LFAs have the most information available to them in deciding whether to file a Form 328. What we will do is, if the LFA files a new Form 328 and there's a pending proceeding involving that LFA, what we will do is combine all of the records, either the record in the opposed petition for effective competition filed by the cable operator and the certification filed by the new certification filed by the LFA, and any petition for reconsideration that a cable operator files, and we will basically, on the basis of the total records and all those proceedings, being informed by the new presumption of a competing provider effective competition, we will just determine whether that the LFA should be permitted to regulate rates, and we will also, in that same proceeding, determine whether the petition for effective competition or application for review or whatever it was that was pending, whether the cable operator had met its burden under that as well. And so hopefully we'll get rid of all of those, and on a going forward basis, the LFAs that have overcome the presumption of competing provider effective competition will be eligible to regulate rates in their communities, and we will move forward on that basis. Nancy, do you think I left anything out?
I think you covered it.
Okay, so we're happy to take questions. We got one already, I think, from Jerry Lederer, who would like to know about when the decision on the extension request will be made. And I'm not...
I think it went, Jerry, I think your question went to you guys? Or was that one for Ryan?
I hope it's for Ryan.
I think maybe it was for Ryan. That's what I thought. Yeah, that's what I think.
I'm either not doing my job very well.
No, that's right. I thought it was for Ryan, but I thought I would just check. So we'll talk to Ryan about that. But are there any questions on the nuts and bolts of effective competition? I think Nancy and Steve did a great job, so perhaps there aren't any. You could either send it to me, gregory.vadas@fcc.gov, or the live question email address, livequestions@fcc.gov. Maybe we'll just wait a minute or so, see if any come in. Really, now's your chance if you're at a local, if you're at the telecommunications office of your county, municipality, city, to ask any questions you may have. Please don't be afraid. This is a time when we have the experts in the room, and they're here to help you. And that's what this is for today.
And while we're waiting for questions, I'll go over one thing that I left out, which is under our old procedures, we had rules that allowed cable operators to get competing providers' reach and penetration rates for purposes of them overcoming the old presumption of no effective competition. We've revised those rules so to make it clear, if it wasn't already clear, that LFAs are covered by those rules, so that in trying to overcome the presumption of competing provider effective competition, they can go to other providers in the franchise area and ask for pure reach and penetration information, which would just be the number of subscribers that they offer service to and the number of subscribers they actually serve. And they are also eligible to get DBS subscriber reports from the Satellite Broadcasting and Communications Association, the way cable operators receive those same reports in the past.
Okay, I don't see anything coming in. We're running actually a bit ahead of schedule because we haven't had any questions. But if you do think of any, or you go back and you say, I should have asked this, I should have asked that, please, again, go ahead and email it to the live questions or myself, gregory.vadas@fcc.gov, and we'll work with Nancy and Steve to answer your questions. And thank you for your time, and please feel free to send the questions. We will, we had a break built in just because we never know how many questions are going to come in or not come in. So we're running a little ahead of schedule, and we're going to pick up again at 2:15 to hear about the robocall order, the Commission's protection against unwanted calls and text. And there will be a PowerPoint presentation up after the webinar, be posted on the event page that our next speaker will that our next speaker is going to use, and that'll go up again after the webinar. Okay, thanks. We'll pick up again at 2:15. Thank you. Welcome back to our to the FCC State and Local Government webinar. Our final topic of the day is the Commission's June order that strengthened consumer protection against unwanted calls and text, otherwise known as robocalls, all those calls we love to get in the evening during dinner time. To speak about this, we have Christy Lemoyne, an attorney in the Consumer and Governmental Affairs Consumer and Governmental Affairs Bureau Policy Division, and Christy has a PowerPoint that she's put together that'll help us run through this order dealing with the series of petitions for declaratory rulings, and what it really does is it clarifies our existing rules because we know there were a number of questions on them. So, Christy, take it away. Thank you. Again, you can either email myself, gregory.vadas@fcc.gov, or go to or email questions to livequestions@fcc.gov, or if you're on Twitter, it's #FCCLive. Thank you. Sorry, Christy.
Sure. Hi, good afternoon. I'm going to be talking through basically what most recent declaratory ruling and order regarding TCPA decided, what the Commission's ruling says. I'm going to start by telling you a little bit about what the TCPA is. We're going to talk through what the declaratory ruling and order decided, and then I'm going to finish by telling you what the Commission considered in reaching those decisions. So I'm going to assume that you don't know anything about the TCPA, so let me start there. The TCPA was enacted in 1991 to address certain practices that Congress thought were an invasion to consumer privacy and a risk to public safety. Congress had a few goals. One of those goals was to reasonably accommodate individuals' rights to privacy, as well as legitimate business interests of telemarketers and other callers. So Congress was trying to accommodate both of those goals, both consumer privacy interest and business interest. Congress recognized the legitimacy of telemarketing, but Congress also said that unrestricted telemarketing could be an invasion of privacy and a risk to public safety. But it also, remember this was 1991, and Congress wanted to afford greater protection to wireless consumers who were likely being charged per call. So keep in mind, 1991, wireless consumers got special protection because of the high rates of charges for wireless consumers. So what does the TCPA do? Two big things that it does. It regulates robocalls and it regulates junk faxes. What is a robocall? It's any call that is made with an auto dialer or where the content includes artificial or pre-recorded voice. And then junk faxes are unsolicited advertisements faxed without prior express invitation or without permission. More specifically, what does the TCPA do? It prohibits making telemarketing calls using an artificial or pre-recorded voice, like I just said, to a residential telephone, and it prohibits making any call using an auto dialer or an artificial or pre-recorded voice to wireless telephone. So it regulates calls both to residential lines and to wireless telephones. There are two main exceptions to that. Those are emergency calls. Emergency calls don't necessarily have to, or don't have to have the same level of consent. And also calls where the called party has given prior express consent for the call. So if you've given your consent, or if a called party has given consent for the caller to make that call, then those calls can be made by the caller. Now, the TCPA also establishes the type of consent or the level of consent required to make certain calls using an auto dialer or a pre-recorded or artificial voice. And there are three levels of consent that the TCPA establishes. Either no consent, that's the first level, or prior express written or oral consent for some calls. And the most restrictive is prior express written consent for some calls. The TCPA also sets time of day restrictions for placing telemarketing calls, which is why chances are you're not supposed to be receiving telemarketing calls after a certain time at night or too early in the morning. It outlines procedures for compliance with the National Do Not Call Registry. It grants consumers a private right of action for TCPA violations. And like I said, it restricts unsolicited faxes. As Greg mentioned, the Commission just issued a 2015 TCPA declaratory ruling and order, which around here we're calling the omnibus item because it covered a lot of ground. What did it do? Well, the Commission voted to adopt it on June 18th, 2015. It was released a few weeks later, July 10th, 2015, and it became effective upon release. So July 10th, 2015 was its effective date. It resolved quite a few different petitions, 19 petitions for declaratory ruling or exemption, 1 petition for rulemaking, and 1 letter from the National Association of Attorneys General containing a request for clarification. So 21 items in all, or 21 different requests in all in that one item. The declaratory ruling portion of the item offers clarification to terminate a controversy or remove uncertainty, and I'll talk in detail about what those different clarifications are. And then the order portion grants exemptions from the TCPA's consent requirement for free-to-end user calls to wireless numbers with very specific conditions. So the order portion of it is different from the declaratory ruling portion. The order portion of it says you don't have to have consent to make these calls if you meet very specific criteria. And again, I'll go into detail on what those are. So what does the declaratory ruling portion say? And again, there are a lot of items here. It's going to get really nitpicky, so we're going to make this PowerPoint available, I believe, for you.
Absolutely, it's going to go up right after today's webinar. So so everybody out there doesn't have to scribble too fast and furious. We're trying to make it easy for you guys. Okay?
Yeah. And this boils down, like I said, the very detailed determinations from the declaratory ruling and order. I think that's a 138-page document, including the commissioner and the chairman's statements. So this is the nuts and bolts of that item. So first, the first thing that it does, it says that nothing in the Communications Act or the Commission's rules prohibits carriers or other service providers from implementing consumer-initiated call blocking technologies. In other words, telephone companies can offer to consumers, at a consumer's request, call blocking technologies on their phone services. Wireline and wireless carriers, as well as VoIP providers, are free to provide consumers services and technologies to block unwanted robocalls. There was a question posed by National Association of Attorneys General asking whether the Commission's rules allowed carriers to offer call blocking technologies, and the declaratory ruling portion said yes, you can do it. There's nothing in the Commission's rules that prohibits that. Second, the Commission clarified the definition of an autodialer. I said that the TCPA regulates calls made using an autodialer. And so we again clarified the definition of an autodialer and said that equipment meets the TCPA's definition of an autodialer if it has the capacity, and that's a term in the definition of autodialer, to store or produce random or sequential numbers and to dial them even if that equipment is not presently being used for that purpose, including when the caller is calling from a set list of numbers. If the equipment lacks the present ability to dial randomly or sequentially, it can still have the capacity to do so. And that means that capacity is not limited to the equipment's current configuration, but also includes its potential functions. In other words, modifications that can be made through hardware or software. Again, I know this is nitpicky. There's more information in the declaratory ruling item itself if you're interested in exactly what that means. It also said that callers cannot avoid obtaining consent to make autodialer pre-recorded calls by dividing ownership of pieces of dialing equipment that work in concert among multiple entities. In other words, if I have a piece, if a dialing equipment, if I divide it into two pieces of equipment, I own one, I give one to my next door neighbor, but neither one works by themselves, they only work jointly together. But because I've divided them among two owners, I'm saying, well, surely it's not an autodialer. Well, if they work jointly to be an autodialer, then yes, those, even though you've divided them, if they work jointly, it is still an autodialer. The Commission also talked about apps that you use on your smartphone, and said that an application provider that plays a minimal role in making a call, such as just providing the app itself, is not the maker of a call for TCPA purposes. Again, I know that's a big picture statement. There's more information and examples of apps that are and are not makers of the call in the item itself. It also said in the declaratory ruling that consumers that have previously consented to robocalls may revoke that consent at any time and through any reasonable means. This is big for consumers. There was a question over whether consumers could revoke consent that they had given. If you signed a contract or if you made an agreement and said, yes, I'll do this and you can call me on my cell phone, and then later you decide, no, I don't want you to call on my cell phone, can you revoke that consent? And if so, can you revoke it in any way? Can you revoke it at any time? Can a company limit the means in which you can revoke and say, oh, you can only do it in writing, or you can only do it by calling this number? And the Commission said a caller cannot limit a reasonable method of revocation. So any reasonable means for revoking consent is allowed. The Commission also said that the burden is on the caller to prove that it obtained the necessary prior express consent. In other words, callers need to keep records of the consent that they've obtained and be ready to produce those. The Commission said that prior express written consent requirements apply to each call made to a wireless number rather than to a series of calls to a wireless number made as part of something like an advertising campaign as a whole. If you're making advertising campaigns, if you're doing a series of text messaging campaigns, you need to be sure that the consent that you have is not for the campaign as a whole, but is for each call within the campaign. And again, if that's something that you're doing, or if you're looking at callers making campaign calls, and I don't mean political campaigns, I mean an advertising campaign, you're going to want to look more closely at the details of that. The Commission also said that being on an acquaintance's wireless phone contact list, in other words, think of the contact list on your telephone. If you're on my phone contact list, that is not the same as having consent to receive calls from providers of apps on my phone that I have downloaded. Consent actually has to be from the called party, not just being. It has to be prior express consent. It can't be presumed consent. It can't be. It has to be express consent. So just being in someone's contact list on their phone is not sufficient consent to receive calls from a third-party app downloaded on someone else's phone. The TCPA's restrictions on auto-dialed and artificial voice and pre-recorded voice calls to wireless numbers apply equally to telemarketing and informational calls. And again, this is for wireless numbers. So there was a question on whether consent had to be, on whether the TCPA's restrictions applied for both telemarketing and informational calls to wireless phone numbers. And the Commission said again that content of those calls to wireless numbers does not matter. Third on this chart, or on this screen, the Commission said that provision of a phone number to healthcare providers, so think about giving your phone number to your doctor, constitutes prior express consent for healthcare calls subject to HIPAA by a healthcare covered entity and business associates of that healthcare covered entity acting on its behalf as defined by HIPAA. Let's put many caveats in there. If the calls are within the scope of the consent given. Again, if you're making calls under HIPAA, you're going to want to look more closely at that. Another HIPAA-covered call clarification was that a caller can make HIPAA-covered healthcare calls to a patient's number provided by a third party during a patient's period of incapacity. Now, this is not going to be broadly applicable, but we had a question on incapacitated patients obtaining their consent. Who can provide consent for incapacitated patients? And so the Commission provided clarification on that. Still in the declaratory ruling portion, remember I said there were 19 petitions here, so we're still moving through those. The Commission said that consent survives when a phone number is ported from wireline to wireless, or vice versa. So porting a number is, I have my wireline phone number coming into my house. I want to take that same phone number and move it to wireless service, but it's still my phone number. I gave consent when it was a wireline phone number. Do I have to give new consent when it's a wireless phone number, or does that consent still carry over? And the Commission said the consent, that porting that number doesn't change, that the consent survives. The consent still must be sufficient, though, for the type of call. So it had to be written consent for a telemarketing call. The Commission also said that text messages are calls under the TCPA. So just like you get a call on your phone that's a voice call, text message is a call to your cell phone under the TCPA. And so auto-dialed text messages are subject to the consent requirements just like any other robocall to a wireless number. Internet-to-phone text messaging technology, where an email is addressed to a wireless phone number and converted to a text message, or a text message is entered from a carrier's web portal. The Commission said that yes, that is covered by the TCPA and is subject to consent requirements. This one, again, is going to be a limited audience, but if you were doing one-time on-demand text messaging sent in response to a consumer request, those do not require separate consent, and the Commission granted 2 petitioners a limited waiver for those. Again, if you are one of those 2 petitioners, chances are you already know the result of those, but that's specific to on-demand text messaging. And that is, one more on declaratory ruling. And these are specific to reassigned wireless numbers. Now, reassigned wireless numbers became a very interesting topic and has gathered a lot of attention around here. Reassigned wireless numbers are when I relinquish my wireless telephone number for whatever reason, and my wireless company reassigns that to John Smith. John Smith suddenly starts getting all of these phone calls that were supposed to be coming to me, but callers don't know that I no longer have that phone number, that John Smith has that phone number. And callers may not know, or may not in a timely way know, that that number now belongs to John Smith. And so we were getting questions from petitioners wanting to know about calls to reassigned wireless numbers. And the Commission said that the TCPA requires the consent of the party called, the subscriber to a phone number, or the customary user of that number. Think business plans, family plans, not the intended recipient of the call. In other words, it's not necessarily relevant who you intended to call. If you intended to call Christy, but it's not Christy's number, it's John Smith's number, the TCPA requires the consent of the person, of the party called, not the intended recipient of the call. So that means that callers have an incentive to use best practices such as database checks or email confirmation to ensure that they are calling the person who gave consent and not another person to whom that number has been reassigned. This, again, is a big issue. If you're making robocalls, auto dial calls, you're going to want to read more on this in the item itself. And then callers who make calls without knowledge of reassignment of a wireless phone number and with a reasonable basis to believe that they had valid consent to make that call to the wireless number should be able to initiate one call after reassignment as an additional opportunity to gain actual or constructive knowledge of the reassignment and cease future calls to the new subscriber. In other words, we're giving you one chance to get it wrong before you have to get it right. When you thought that you had actual consent to make that call and it ended up being a reassigned number. If this one additional call does not yield actual knowledge of the reassignment, the caller is deemed to have constructive knowledge of the reassignment. And again, there's more information in the item itself over what those terms mean. And that is what the declaratory ruling portion did.
Christy, let me just jump in
Okay.
and say it's an excellent PowerPoint. And I just wanted to give anybody who needed even more detail than is in the PowerPoint the FCC number of the item. It's FCC 15-72. And if you go to the Commission's homepage and you click on headlines and then you click down to more headlines until you get to June 18th it came out?
I believe it was
It's
either on the June
18th. It's June 18th
or July 10th. No, it is under June 18th.
It's on,
correct.
right. And so under headlines, you click down to more headlines and then keep scrolling down until you get to June 18th, and then you can click on the order itself and download it if you need more detail.
You can also search in eDocs
Right.
under docket 02278 for June 18th. Is another way to find it.
Okay.
So those are the declaratory ruling sections. The final section, and this will be much faster, is what the order portion does. And these are calls for which the Commission granted exemption. The Commission has granted an exemption in one other case. That was for a cargo airline order. I'm not going to talk about what cargo airline order did, but this is the second time the Commission has granted an exemption. The exemptions... I went forward too far. No, I didn't. Sorry. The exemptions are for certain financial and healthcare-related calls. These calls have to be free to the consumer. In other words, they can't be charged to your cell phone. And they're exempted from the TCPA's consumer consent requirement. In other words, because they are free to the consumer, to the called party, the caller does not have to have the consent of the called party. The exemptions apply to HIPAA-covered healthcare calls and to specific financial calls. And I've put on the screen, I won't go through them, which healthcare calls and which financial calls, because the Commission was very clear over what categories of financial calls and what categories of healthcare calls are included in the exemptions. The exemptions are subject, like I said, to strict conditions to protect consumer privacy. There cannot be any telemarketing or any debt collection content in these calls. Even billing-related content cannot be in these calls. And there's a requirement that in each message there must be a way to opt out of future messages. So whether that's a text message or whether it's a voice call, there has to be information in that call saying telling a called party how to stop future calls. If it's a financial content call, those calls are limited to 3 messages, whether voice or text, per event. And again, the event is explained in the document over a 3-day period for an affected account. And then healthcare calls are limited to 1 message, voice or text, per day, up to a maximum of 3 per week for a specific healthcare provider. So it's limited in content, it's limited in frequency, and it's limited in topic. These exemptions are. And again, it's got to be free to the end user, and they can be made without consent. And that's why they're exempted from the TCPA's requirements. So that's what the order portion says. Now, I told you I'd get to the part where we explained how the Commission reached all of these decisions. I said at the beginning that these decisions were made in response to 21 different documents filed with the Commission. The Commission, in reaching the decisions, considered several different sources. The first was the TCPA itself. The Commission is bound by the terms of the TCPA. The Commission also considered legal precedent. That would include prior Commission decisions, if the Commission has spoken to a term before, if it's defined a term, if it's stated something clearly before, the Commission is bound by that. We also considered court decisions, legislative history, congressional history, other legal authorities. The Commission considered public comments. Each of these petitions that were filed was put out for notice and comment, and the Commission received over 1,000 comments on these petitions that were all considered, all were read, many were cited in the document itself. The Commission heard from the Intergovernmental Advisory Committee. They provided an advisory recommendation on the TCPA matters, and the Commission cited to that recommendation 6 times in the decision. And then finally, from information meetings with interested parties, including representatives from other federal agencies. All of this information is contained in the record in the dockets 02278, and there's one other docket. It's in 02278. Do you have that, Greg? It's going to look real quickly.
07135?
07135. Those 2 dockets is where all of that information is contained, and it is all available to the public on the Commission's website. And there you go.
So I don't see any questions streaming in right now, but I do know on effective competition we had a number of questions after our speakers have left the room. So we're going to wrap up now, but if you have any questions, go ahead and email to livequestions@fcc.gov, and we'll get them, or you could email it to myself, gregory.vatis@fcc.gov. Hopefully this explains it, and Christy's PowerPoint gets you what you need, but if not, go ahead and go to eDocs on the Commission's website, and you can just put in under FCC, put in 15-72 and pull it up. Or in the headlines portion, if that's easier, go into it, scroll down until you get to June 18th, and you can pull the Commission order. Okay. Thank you for joining us today. We hope this was useful. I'd love to hear your feedback and what you'd like to hear about next time. And that's it. And also, we are your I should say our office, the Office of Intergovernmental Affairs, is your main contact here for state and local governments. The FCC is a big place, and hopefully we can get you what you need, help get the experts to answer your questions and get a little more attention to it. So thank you.